This is a final passage which was dictated in senior PA examination of Delhi High Court. So be ready. 5 seconds to go. The present batch of writ petitions is concerned with admissions for the first year law course in the private law colleges affiliated to different universities in the state. The petitioners in writ petitions are law colleges and they seek a writ of mandamus declaring that they shall be entitled to select the candidates to the first year law course on the basis of the marks obtained by them in the qualifying examination and without reference to the national level entrance examination. The petitioners in another batch of writ petitions are the candidates who claim to have joined the first year law course without passing the entrance examination and without obtaining any interim directions from this court. Their plea is also the same. One more writ petition is also filed for the same relief and the same is filed by a law college and its 60 students who claim to have joined the first year law course in the said college. Relief sought for in this batch of writ petitions is the same. Questions of law involved are also common. Therefore, it is proposed to dispose of all of them by a common order. Number of counsel have advanced arguments. Points urged by them relate to legal and factual aspects. It is submitted that the provisions of the Advocates Act enacted by the Parliament under the Constitution of India occupy entire field of legal education including admission to law courses and therefore the rules pertaining to entrance examination are unconstitutional, invalid and inoperative. It is also submitted that the rules of entrance examination are contrary to the provisions of the University Grants Commission Act and as such they are invalid and unenforceable. The council further submitted that neither the state government nor the universities have power to prescribe additional or higher qualifications than those prescribed by the Bar Council of India from time to time by way of rules made under the Advocates Act. It was also argued that the entrance examination rules are repugnant to the rules made under the Bar Council of India and therefore they are void. It was also submitted by the Council that the Bar Council of India has no power to subdelegate its power either to the universities or the state government and as such its resolution is bad. It is also argued that the right to run the colleges is frustrated for the reason that the convener failed to allot sufficient number of candidates to each college and the entrance examination rules have become superfluous at the present stage when seats are more and the candidates are less. Now, it is for the court to examine whether the entrance examination rules are invalid and inoperative in view of the rules made by the Bar Council of India under the Advocates Act and whether there is any repugnancy between the rules made by the Bar Council of India and rules of the entrance examination. At this juncture, it is necessary to state that as per the orders of this court, the Bar Council of India was impleaded as a respondent in all the writ petitions. Thereafter, matter was adjourned thrice to enable the Bar Council of India to file its counter affidavit, but its attitude was callous and deplorable. No counter affidavit was filed on its behalf.